beck and call of the central government.
No.
Why have an elected government?
I bow down. I am kindly, my lord.
See how anomalous this would be. If an officer is not discharging his functional role properly, the Delhi government will have no role then to say that, well, I'll shift this person and get someone else.
Lord,
Can that ever be? If functional control you concede in terms of the TBR also has to be with the Delhi government, then can we say that, look, you will have no, they will have no jurisdiction or no authority in respect of where he will be posted, whether he should be in education or whether she should be in environment or whether she should be in somebody else should be on something else.
Lord, I'll answer that question. Lordships, my lord, would test whether a particular subject, particular matter, not entry, but the particular matter can ever be within the domain of the union territory or not. As a class, not Delhi, as opposed to federating states. Now, taking an example, my lord, of services, as I have already indicated, I'm sorry.
Yes.
As I have already indicated, Lord, union territories are extension of the union government by definition and even constitutionally. The very purpose of creating one particular geographical area as a union territory by itself suggests that the union itself wants to administer that territory, meaning thereby through its own offices. Yes. So, all union territories are administered by central civil services officers, and they are all central government officers.
Then what is the purpose of having an elected government in Delhi at all?
Yes, I'll just answer that.
If the administration is to be carried out only at the beck and call of the central government,
no.
Why have an elected government?
I bow down. I am kindly, my lord, distinguish two things, my lord, and that everything will fall in place. The functions of the officers and administrative or disciplinary control of the officers. I'll just illustrate, my lord. When a central service officer, IAS officer or Denics officer, is posted, say at Dadra Nagar Haveli or in this case Delhi, as say particular commissioner where he is empowered, he is entitled to, or he is under an obligation of issuing licenses, then he will be guided by the policies of the state government. He will be I have shown the terms, the transaction of business rules. He will be answerable to his minister. His minister will formulate the policy of license, how to give license, how not to give license, what are the parameters to be considered, how this ministry would run. That functional control will be that of the minister, of the elected wing. We are concerned with administrative control. Who puts, who appoints, who posts, who transfers, who departmentally prosecutes. That officer cannot ask the Home Secretary whether I should give the license or not. He may have to ask his minister that whether I should give license or not. So there are two different things. Functional control is obviously with the minister concerned. That's the transaction of business rules.
But suppose the officer is not properly discharging functions. Now see how anomalous this would be. If an officer is not discharging his functional role properly, the Delhi government will have no role then to say that, well, I'll shift this person and get someone else.
Can
that ever be? If functional control you concede in terms of the TBR also has to be with the Delhi government, then can we say that, look, you will have no, they will have no jurisdiction or no authority in respect of where he will be posted, whether he should be in education or whether she should be in environment or whether she should be in somebody else should be on something else.
I'll answer that question, and I must
road construction
squarely. Lord, the examples given were, my lord, very, very simplistic examples that I don't want this man to be in the health and I want him to be in the industry. Look, can I not do that? Lord, let us examine the fundamental question why that control is necessary. Suppose the central government, as per the rules, my lord, which I will show, posts a particular officer as industries secretary or secretary environment or any other secretary. Delhi is the capital of the country. But I'm sorry, Manoj, but this maybe really, Lord, going to the root of it. Lord, we have neighboring states. Capital has neighboring states. And maybe as per the policy of the Delhi government or irrespective of the policy government, he starts having a non-cooperation with some secretary dealing with the similar department in, say, Punjab or Haryana or Rajasthan or UP, continuously. Suppose Haryana person, Home Secretary, is dealing with, say, terrorism or dealing with some act, and this man never cooperates. Lord, would it not be imposing a question to myself necessary for the state government to say that no, you remain there, but you are shifted to health? Suppose health secretary, maybe as per the policy of the government or as per his own whims, start acting in a manner that there is an epidemic, either spread of epidemic, there can be a policy, but not, there is an epidemic or pandemic, and some actions are not taken for some reasons, which might have an all India implication. The state government must retain its control. And if there is a bona fide reason that this officer misbehaves, this officer is not suitable for the post, this officer has committed misconduct, then disciplinary authority is undisputably, as per law, the Ministry of Home Affairs. You just indicate the law, LG, that you transfer this officer, and LG is under an obligation to forward it to the cadre controlling authority. That's how the scheme has worked so far. Lord, I have the list. Whenever, Lord, there was a request from the minister that either appoint somebody from bringing from somewhere to my department or transfer someone, LG is just intimated in writing and the necessary actions are taken. But as a law, as a constitutional proposition, Lord, that power is retained with the central government by LG as a representative of the President of India, because you are administering the capital of the country. I am not on functional control.
In the reference is made to the cadre rules. You will have to, in your own way, you tell us.
I will. The 11A
rules. Then when the postings are to be made,
yes,
the cadre rules, once the allocation is made to a particular state or a union territory where state is defined to include a union territory. Once the allocation is made, the rules say that the postings are to be left to the state. That is one. You address us.
I'm sorry.
On that issue.
My apologies.
Flagging that. Dr. Singh, on the other hand, also said that postings will vest in me as a state, but the union could continue to have the disciplinary authority. So therefore, we have a duality. In IAS, we know invariably the cadre controlling authority is always the union because DOPT will control that. But with respect to the postings, assignments invariably happen by the chief secretary or GID department. How does
states? Yes, I'm sorry.
Tell us the distinction as against a state in a union territory, number one, first layer, and as against union territory so far as NCTs are. There is a further difference there.
Yes.
In your own way, you will have to answer that question.
Lord, I'll just let you answer that first. Lord, kindly come to my written submissions.
Now, while you're at it, Mr. Mehta, also vis-a-vis other UTs, is that how you're doing it?
Same thing. Yes, I can make that statement. Through administrator. In Delhi, the difference is administrator's nomenclature is LG, but he is not a governor in that sense of the term constitutionally. He is an administrator. He is an administrator, having the powers of the administrator under Article 239 of the Constitution. But answering that first, my lord, since it fell from your lordship's. My lord, the scheme under the administrative infrastructure in India is this. All India service officers are appointed under the All India Services Act. There are several All India services, Indian Administrative Service, Indian Police Service, Forest Service, etc., etc. The examination is, my lords are aware, conducted by the UPS. The moment, my lord, I clear the examination, I will be given the option of choosing my cadre. I can choose my home cadre. Somebody may choose some other state, etc. My lord, there are 3 options to be given, which is not relevant, my lord, for the present purpose. Just, my lord, I am giving an idea. And depending upon my ranking in the, my lord, list, I get the cadre. One of, my lord, all are state cadres, except one. That is called eqnuire cadre. And eqnuire cadre, my lord, includes
Andaman, Nicobar and all that.
Arunachal Pradesh, Goa, Mizoram, Andaman and Nicobar, Chandigarh, Daman and Diu, Dadra and Nagar Haveli, NCT Delhi, Lakshadweep, Puducherry, Jammu and Kashmir and Ladakh. So this is, my lord, a joint cadre, and therefore if I am allotted eqnuire cadre, I can be transferred only in one of these,
Right.
my lord, UT or the state, my lord, because Arunachal subsequently became state, Goa became state, Mizoram became state, rest are still UT. So I will be appointed in some of these, my lord, states only and not outside. There is no separate cadre, union territory wise. Now, my lord, immediately answering, and then, my lord, I will take your lordship to this, my lord. But broadly, my lord, kindly bear one factor in mind. So far as Delhi administration is concerned, there are 3 layers, there are 3 tiers. First is All India Service. Second is DENIX. DENIX, my lord, stands for Delhi, Andaman, Nicobar, Lakshadweep, Daman and Diu, Dadra and Nagar Haveli, central services, civil services. But it is a central service, I will show. So selected by UPSC, it is a central service. They are central government employees.
Normally referred to as Group B services.
Group B services. Your lordships are right. That Group B.
IAS exams, everybody knows.
Pardon?
In the IAS examination, people know. Group A, Group B services.
Group B services. My lord. That is, my lord, the second tier.
Most
And
hierarchy conscious institutions.
yeah, those who are selected in Group B, then again they attempt and try for Group A, etc. And the third tier is what is called DAS, DASS, Delhi Administration Subordinate Services. That is, my lord, Group C services and C and D services. Now the appointment is, my lord, for first 2 tiers, the appointment is made by
UPS.
the UPSC. So far as third is concerned, the central government has created a board, selection board, service selection board. So class group D and C and D are selected by them.
Have you formulated this in your submissions?
Yes.
In your selection submissions? Why don't we then quickly look at that paragraph so we bring focus on that?
Yes, Manoj.
Since in the morning.
Page 52, Manoj.
I know.
Yes.
Yes.
On services.
Page number? Sorry.
Lord, if your lordship don't mind, kindly come to page 55.
55.
But before that, if your lordships can just take the constitution, the chapter of services. Lord, part 18, 14, Lord, starting with 308, article 308. Your lordships are dealing with a question as to whether services and state service commission can fall within NCT of Delhi or not. Lord, kindly, Lord, this is slightly crucial. If I can show that there cannot be a state public service commission in NCT of Delhi, Your lordships would not bifurcate entries that half entry is available and half is not available. Correct, my lord? That's a settled law of constitutional interpretation. Now kindly see 308. I have already, my lord, indicated this in the beginning. In this part, unless the context otherwise requires, the expression state does not include the state of Jammu and Kashmir. I have already said this was same Seventh Amendment where Union territory was introduced, and therefore the legislative parliament has consciously not used the word Union territory here. Now see 309, which I have already read. Now kindly come to 315. Then I'll take your losses through the written submissions. Subject to the provisions of this article, your lordship gets, my lord?
Yes.
There shall be a public service commission for the union and public service commission for each state. So first of all, literal interpretation means it is the state which can have public service commission. UT is excluded in 308. That is the first submission. Then 2, which becomes more clear. 2 or more states may agree that there shall be one public service commission for that group of states, and if a resolution to that effect is passed by the House, or where there are 2 houses, by each houses of the legislature, those states, Parliament may by law provide for the appointment of a joint state public service commission referred to in this chapter as joint commission. Here also, it is kindly now see 4, sub-article 4. The Public Service Commission for the Union, if requested so to do by the governor of a state, may with the approval of the president agree to serve all or any of the needs of the state. And kindly see, my lord, the asterisk. What is removed? Raj Pramukh is removed.
315.4.
My lord, Article 315, sub-article 4, I'll read again, my lord, the Public Service Commission of the Union, UPSC, if requested so to do by the governor of a state, may, with the approval of the president, agree to serve all or any of the needs of. So, the governor has the power, and kindly see, my lord, the governor is replaced by Raj Pramukh. Raj Pramukh was only for group Part A and Part B states. That is, constitutional, the federating states. Part C was, Delhi was Part C state. And most importantly, this Raj Pramukh is also deleted and governor is made by the very same amendment by which union territory came into picture. So this completely excludes a possibility of union territory having a public service commission. Now kindly see, my lord, 316.
One minute.
Lord, I hope, my lord, I am able to make myself clear. Lord, the submission is the very same amendment, namely 7th constitutional amendment, which introduces union territory, which introduces administrator for union territory, amends Article 315 to include only the governor, meaning thereby here state means state, not union territory.
Yes.
Correct? Now, 316, only one, sub-article 1. The chairman and other members of a public service commission shall be appointed in case of union commission or joint commission by the president and in case of a state commission by the governor. There is no provision for administrator appointing the chairman because there cannot be a service commission for union territory. Reading Article 30A, 315 and the 7th constitutional amendment, which all brought this scheme together. Reading them together, they cannot be. So if one entry says state services and state public service commission, if I can satisfy your lordship that there cannot be any public service commission for union territory, then contextually the subject of services also is out, because your lordship would not bifurcate it. The legislative power would be available for half of the entry and would not be available for half of the entry.
You are driving at the proposition that their constitution do not contemplate services for union territories.
Correct. I am
independent of the union services.
Yes, there are only two services contemplated under part 14, union services and state service. For union territories, the union services go and serve. There is no third category of service.
Otherwise, it will be equated with the state,
Correct.
union territory.
Correct. Or maybe central services, because union territory is an extension of union.